In the Federation Chamber, I raised the concern of a range of national trade unions about the impacts of the China Free Trade Agreement on their members and on working people more broadly. I've got a report to the House that the concern expressed by representatives of Labor is also matched by concern expressed on behalf of business, and indeed no less a body than the Productivity Commission has launched what's been described as a scathing attack on Australia's latest series of free trade agreements, saying that they grant legal rights to foreign investors not available to Australians, expose the government to potentially large unfunded liabilities and add extra costs on businesses attempting to comply with them. The Productivity Commission has devoted a special chapter of its Trade and Assistance Review, which was released yesterday, to the agreements, and it describes them as preferential rather than free trade agreements. And I've got to say I've always had that view myself, that they weren't actually free trade agreements and might more properly be described as bilateral trade agreements. But I'm happy to embrace the expression used by the Productivity Commission that they be referred to as preferential agreements. And the Productivity Commission goes on to say that by favouring some countries over others and excluding firms from sourcing substantial inputs from other countries from special treatment, they, quote, add to the complexity of international trade and investment, are costly and time-consuming to negotiate, and add to the compliance costs of firms and administrative costs of governments. The Commission says that the Japan and Korean agreements were concluded without a rigorous and independent assessment of whether costs would exceed benefits, and that there was also no mechanism in place to monitor the outcomes of the agreements after they come into force. In the Trade Review they say, without such a detailed assessment, it is not possible to form a view as to whether the aspirational goals typically ascribed to the formation of preferential agreements are commensurate with real-world impacts. And it's a pretty important point, Mr Deputy Speaker, because we've had trade agreements that we've entered into with a range of countries over the years, and at the time there are all manner of glowing accounts given of what their benefits will be for Australian business and for Australian workers and so on, but we don't often come back and find out what the outcomes of these agreements have been in practice. And indeed, in relation to many of the countries with whom we've engaged in trade agreements, we've in fact found an increasing trade deficit and some negative impacts on the Australian economy and on Australian workers as a consequence. So they make a very important point about the lack of mechanisms in place that monitor the outcomes of these agreements once they come into force. The Productivity Commission also notes that the history of intellectual property arrangements being addressed in preferential trade deals is not good, and it's being noted, this is not so much about the China Free Trade Agreement but about the proposed Trans-Pacific Partnership, that the leaked text suggests that it will include obligations on pharmaceutical price determination arrangements in Australia and other TPP members of an uncertain character and intent. And I think this is an important point as well. We have both in the Korean and Chinese agreements investor-state dispute settlement clauses which depart from national treatment principles by affording substantial appeal rights to foreigners that are not available to domestic firms. And the Productivity Commission warns that this could create the risk of regulatory chill, where Australian governments will be cautious about enacting new laws for fear that they're challenged in foreign tribunals. And I think that's a very important point, Deputy Speaker. I think it is most unsatisfactory that we have a potential situation where Australian businesses are in a poorer situation than overseas businesses that are able to take advantage of the ISDS provisions in the China agreement. There have been objections to this from a whole range of experts, and I urge the government to have greater regard to them.